you.
Before we go to the approval of minutes, I'd just like to introduce the two new commissioners that are joining us today. First, on my right, Karen Chang, and Mr. Jerry Gibson on my left, for the general public.
I'm very happy to be here. Thank you.
Welcome to the fray.
Thank you.
Okay, Commissioner Flores, your turn.
Yeah, I move to approve the minutes of the open session of September 28, 2017.
Second.
Okay, been moved and second. Any discussion? Commissioner Levinson.
Yes, the minutes are very long, and so it's not surprising that at least reviewing what's in the minutes as to what I had to say, I found some suggested corrections to make. On page 5 at the bottom, the second line from the bottom should read the standard measure of error, not standard area of measure.
And this is for the, I know we got a whole bunch of,
Page 5, second.
what date meeting was
Oh,
that?
this
September
is
28th.
September 28th.
28, okay.
Did you write
The-
Page
Yeah,
5.
the second one is on page 6. The second line, the word error, E-R-R, should be stricken, and error, E-R-R-O-R, substituted for it. And then finally, on page 7, in the last paragraph, 4 lines from the bottom, instead of "for the sake of forum," it's "for the sake of form."
Okay.
Thank you.
Can I have that?
Yeah.
Okay, with those corrections, any further discussion? Hearing none, all those in favor say aye.
Aye.
All those opposed? Thank you very much. We have public testimony. We have one person that has signed up. Lily? Yeah. You have the desk over here, or the chair? Whoa, there's the chair. Okay, good. Just as a reminder, you have 3 minutes.
3 minutes?
Yes.
All right.
And you can have a seat, by the way.
First, I'm talking about my kids. I have 2 kids, twins, being kidnapped by the police, 4 policemen. And it has been a long time. We came over here 2004. The investigator was classify this kidnapping. Because that time, everybody knows this department was very corrupt. Very corrupt. Like, you open your, turn off the light, you cannot even touch your hand. Cannot see your hand. So now they are 23. I've been only see them twice. Boy 1 time, girl 2 times. They get beat up, teeth get pulled out by the CPS. I try to go CPS to connect with all the communication I try to go through. They block the door. God is show me in my dream how they process growing up. I want my kids, I want to see my kids. I couldn't find that. I need you new policeman. You're woman, I'm woman. Mother, you know how that feelings, no matter how time pass. That's your kids. That's my kids. I appreciate for your rebuild community trust. The trust has been broke for a long time for this system. Second, since that times, I get evicted from KPT by 4 statements, one by one. Like nobody else business in court. Everybody make money from 4 statements. I have a state ID. I put outside and couple cash and credit debit card. And there's the workers connected with the police. That time I have a camera. I know who exactly who took it. I report to the police. Get no result. Kapolei Police Department close case. See, you never interested, never investigate. I go over there several times. They close the door on me. I come here, and police station. They said, case being closed. How could be closed? I never get nothing investigate. Have it started. Sir, police refuse to write safety report. Very humbly, politely, walk away, don't say nothing. Just end of it. I don't know, is my 3 minutes up?
Yeah, your 3 minutes is up. If you can summarize, please.
Summarize. I want you, I'm very happy to see you, woman as woman, try to find my kids. That's number one. The theft, my ID, never been opened, never been closed. I got a strange call in the car. They said, no such thing. I had a camera, I know the persons. They never open. They just inside job, one cover one each other. 3, I want police being more efficient, like you said. Not qualified person, not just humble, yes, not like that. Do your work. Do your work. When people get hurt, need help. You said build trust. How? By doing your work. Good deed, good work. Who is watching? You choose where you go. Here or there. You decide anything. I thank you very much.
Yeah. Chief, could you have someone help the lady and get the information?
Yeah, no problem.
Whether the case has been closed or what happened to whatever the complaint?
No problem.
All right?
We'll have the officers outside.
Appreciate it. Lily,
Thank you very much.
they will take your information and see where all the issues are at. Thank you.
I appreciate very much, sir.
You're welcome. Do we have any?
And one thing I have to make sure, everybody understand. He is real. It's not how much money you have. It's not how much position, higher position you have.
very much.
Thank you, Lily. Thank
He
you.
is watching.
Yeah, thank you.
He decided where you go later on.
Okay, thank you. We do have any other testifiers?
No, there's no other
Okay, we do not have. So we move on to new business. Commissioner Levinson.
Thank you. I ask that the notice of appeal of former officer Bobby Nguyen in his administrative appeal against this commission be placed on the agenda. I have a motion to make in connection with it. Does everyone have a copy of the notice of appeal and the attachment?
This was emailed. Did you get this? You got this?
My motion is this, that the police commission instruct its attorneys in this matter, which in this instance is the Office of Corporation Counsel, to confess error in the circuit court on behalf of the police commission. In other words, my motion is that the commission instruct our attorneys to advise the circuit court that the commission is now in agreement with Officer Nguyen's request for legal representation in connection with the Puana v. Kealoha lawsuit and not to defend the action taken earlier by this commission. My motion is based on a Hawaii Supreme Court precedent, which I'd like to take a couple of minutes to discuss or describe with you and for you. It's important precedent, and it so happens that I wrote it. The case is Chun versus the Board of Trustees of the Employees Retirement System of the State of Hawaii, dated March 25, 1998. It's located at 87 Hawaii 152, 952 P. 2nd, 1215. It was a unanimous decision of the Hawaii Supreme Court. Basically, this is what it entailed. The teachers and principals within the State of Hawaii Department of Education were being classified by the employee retirement system as 10-month employees. This affected, of course, their numbers of years in service and other things that affected ultimately their pension and other retirement benefits, and they wanted to be treated as 12-month employees. They filed a claim with the Board of Trustees of the ERS. The ERS found against them. No, you are 10-month employees. They filed an appeal, an administrative appeal, same kind that we have before us that has been filed by Officer Nguyen in the Circuit Court under the Hawaii Administrative Procedure Act. And on appeal, the Circuit Court agreed with the teachers and the principals. I agree, you are 12-month employees, not 10-month employees. The executive director of the employee retirement system, acting on his own and in conjunction with the Attorney General of the State of Hawaii, filed a notice of appeal from the Circuit Court's decision to the Hawaii Supreme Court. But in the meantime, the Board of Trustees of the ERS had changed its mind. It now agreed that the principals and the teachers were 12-month employees and not 10-month employees. And so the chair of the board of the ERS wrote to the Attorney General and basically advised her that she was not authorized by the ERS to appeal the Circuit Court's decision. And the Attorney General responded to the ERS by saying, it's not your call, it's my call. It's my job to advance what I view as being in the best interests of the state, and therefore you are appealing whether you like it or not. That became an issue that our court had to decide. We dismissed the appeal on the basis that the executive director and the Attorney General did not have the authority to pursue the appeal over the objection of the commission. And I'd like to read to you some of the material language of the decision because it's important. And it applies equally to the Corporation Council as it did to the Attorney General, because by law, the relationship of the Corporation Council to this commission is equivalent to the relationship between the Attorney General and the employee retirement system. The authority of the Attorney General in her capacity as the statutory attorney for the board was limited to the exercise of her professional discretion to organize and develop legal arguments to reflect and vindicate the board's lawful policy decisions, and did not empower her to substitute her vision of the state's interest for that of her client. Once the state officer or instrumentality whom the Attorney General represents has determined the course that he or she desires the litigation to take, it is the duty of the Attorney General to zealously advocate the public policy positions of her client in pleadings, in negotiations, and in the courtroom, and to avoid even the appearance of impropriety by appearing to be in conflict with the desires of her client. In summary, the Attorney General's statutory authority to prosecute and defend all actions brought by or against any state officer or instrumentality, and in this case we're talking about this commission, simply provides such officer or instrumentality with access to the Attorney General's legal services, and does not authorize the Attorney General to assert his vision of state interest. The Attorney General stands in a traditional attorney-client relationship to a state officer or instrumentality she is required by statute to defend. Her authority to manage and control litigation on behalf of a state officer is limited to her professional discretion to organize legal arguments and to develop the case in the areas of practice and procedures so as to reflect and vindicate the lawful policy of the officer or instrumentality she represents. The Attorney General is not authorized in such circumstances to place herself in the position of a litigant so as to represent her concept of the public interest, but she must defer to the decisions of the officer or instrumentality whom she represents concerning the merits and the conduct of the litigation, and advocate zealously those determinations in court. Based on the foregoing, we hold that the Attorney General lacked the power, without the express authorization of the Board, to file an appeal on the Board's behalf from the Circuit Court's final judgment. The vote in Officer Nguyen's case with respect to his request for legal representation was 4 to deny and 2 to grant. It's my understanding that one of those 4 votes, or commissioners who cast one of the 4, may have changed her mind on the merits of the matter since then. And I believe that the vote of the chair was made in misunderstanding of what Officer Nguyen's burden was in establishing his entitlement to legal representation. He was not required to testify on his own behalf. In fact, he would have been, in my view, a damned fool to have testified in his own behalf. His testimony would have been irrelevant in any event, and he was not required to present any evidence whatsoever other than the complaint against him itself. What determines the outcome, or should determine the outcome, of a request for legal representation are the factual allegations of the complaint. If the complaint alleges acts done in the performance of duty as a police officer, the requesting officer is entitled to legal representation, whether the factual allegations are true or not, and whether the officer's conduct was lawful or not. And it's clear to me that Officer Nguyen more than met his burden based upon the allegations of the complaint. I think the proof of the pudding is that a few weeks previous to our denial of Officer Nguyen's request for legal representation, this commission granted the request for legal representation of one of Officer Nguyen's co-defendants in the same lawsuit, Officer Akagi. And the allegations set forth in the complaint against Officer Akagi were virtually identical to the allegations directed at Officer Nguyen, and therefore the outcome should be the same. So on the basis of all of that, I make my motion.
Second.
I was going to say, before we do that, I'd like to entertain a motion to take this into executive session, just to confer with court counsel on this issue, and we can always come back out to open session for the vote later. So if we can have, entertain a motion to move this to executive
I
session.
personally don't see any need for that.
All right.
Okay, I'm just entertaining a
I just want to
motion.
say one thing so that I can gather Commissioner Levington's long explanation. If I am the female that changed her mind, and I think I did at one time, it was because I was drowning when you were explaining all of this, and I wanted our court counsel at the time to explain to me. And my understanding was that this officer, Nguyen, passed the time that he had that would make it legal for us to give him that. So I'm for opening it up. I want to make sure I understand, and I don't remember what the vote was. I guess it was 4-2. So.
Yeah, I just wanted to, since we have two new commissioners
Okay,
here,
okay.
with our court counsel, just for discussion purposes, I mean, we can come back out and still entertain the motion for.
Yeah, I think a cop counsel should come out and defend it.
Exactly.
We cannot just sit
Exactly.
on one side
it's-
and listen to this
Yeah,
side.
no,
Yeah.
I understand that, and but because it's client,
Yeah.
what do you call that?
Yeah.
With
Very
respect,
quiet.
Eddie, I think you're missing part of my point. We don't have one side and another side. We're on the same side. The point is that court counsel is our lawyer. We are the client. We decide what our legal position is. If it
But-
is defensible, it's court counsel's job to advocate it, whether court counsel likes it or not. And therefore, I don't see anything to be
I
gained.
just want the two new commissioners just to, hear from court counsel on their part, since they're new. And like I said, we can always come back out and address the issue.
Is it because the corporate counsel has a different point of view?
Yes.
I see.
Yeah.
So.
Well, I have no doubt that court
Yeah.
counsel.
Yeah, yeah.
That's a
I
different point
think
of
that's
view.
what
Even
Eddie
though we're
meant too.
the line.
Yeah, so again, I'd like to entertain a motion to move it to executive session for discussion purposes.
He said
Motion
so.
been made? Do we have a second?
Second.
Oh, no, he
He
moved.
said-
I don't make the motion, I'm entertaining.
Okay,
He said-
second.
Okay, all those in favor to move it to executive session for discussion, say aye.
Is that executive session going to
Yeah.
happen now, I hope, so we don't
Yeah,
have to come
yeah.
back? Okay.
Right after this.
Because it has to be clear to us. It makes sense to what
Okay.
Commissioner
well,
Levinson is saying.
Do I hear hands, see hands moving? Okay. Yeah, we're gonna go to executive session on this
You
and
don't
then,
have, you don't have the proper votes.
what's that?
We
You
don't
don't
have,
have the
Yeah, the
proper
votes.
votes to go to the executive.
oh, why not?
Why is it?
Should I do a show of hands again?
I'm sorry, what?
Three. 1, 2, 3. Only
No,
count
four?
three.
No.
We're four?
Where's the fourth?
Yeah,
Jerry and Eddie?
Jerry.
No, I'm sorry.
Ah.
Didn't see it.
I didn't.
Okay.
Wait, well,
Yeah.
who
What?
raised their hands to go into executive session? 1, 2, 3.
Well, no, if you want advice from court counsel, yeah, I mean, of course. If you ever want to talk to our lawyer,
Sure.
yeah,
Does
of
that have
course.
to be?
Yes,
Okay.
sure.
Okay.
Let's
Yeah.
talk to your lawyer, absolutely.
Yeah.
Why can't we do
Okay,
If
we'll
we're
move that
already
to executive
talking.
session. All right, new business number 2. You all have a letter from Mr. Barney Burvar?
Bernie,
Bur-
Bavar.
Oh, Burvar.
Bernie.
Oh,
Bernie
gee,
Burvar.
Okay, sorry, Burvar. I guess, once he has
Oh,
his
yeah.
name that way. Regarding Commissioner Sheehan.
Yes.
I guess he's not here.
No.
So you all have you all have his letter that was given out to everyone.
Why do they not come? And they want us to do the dirty work. I mean,
So
really.
the next question I have is that
Sickening.
Commissioner Sheehan, would you like to reply?
I
Again,
have no problem with this request, I will recuse myself.
Oh, you will recuse yourself? Okay. Oh, okay.
Yeah, I do work
said-
with Tommy Otaki. I have no problem recusing myself.
Okay, all right. With that, I guess the matter is over.
yeah,
with.
okay, so let's go back to the,
Okay, let's see, the third one is the discussion on performance goal evaluation criteria, Chief of Police. You all were given previous jobs description and evaluation. The timeline for this, I'd like to have it at least by the I guess the next meeting would be the December meeting. Since the evaluation for the chief, I believe, starts, since we give it 2 months to get your house in order, because the next evaluation would be December of next year. So it would be reasonable to assume that it starts from the end of December or towards the end of December. So any comments on that so far?
Yeah, go ahead.
Go ahead.
I have a thought, and it may have merit and it may not, I'm not sure, because I don't have any experience, with this, especially at this stage of the game when we have a brand-new
Yeah.
police chief who is beginning with a clean slate. So it occurs to me that there may be some utility in entering into some discussions with her as to, what her job description is, if that's part of this process. But, and in addition, what her view is as to
I
the
agree.
important,
Yeah.
relevant
Yeah.
performance
Yeah.
criteria.
Right.
What I was thinking about is, we need to at least go to her with something, say, oh, here's our idea.
Yeah,
And,
sure.
and there'll be some discussion between
You know-
the chief and us, and then we'll come up with a
She
thing.
can
That's
react.
kind of like what I
Can
was
react.
thinking.
Well, you,
know.
I
you
agree.
provided us with a packet that consists of, I think, what has been used up to this
Yeah,
point.
yeah.
And also, what was developed
Along the way.
Along the way.
along
yeah.
the way, I
Yeah.
think, during the past two tenures, not counting that of Acting Chief Okimoto. And so we can all have that before us when we have these discussions, but I think, I would find it very useful to involve the chief in the process, but
Yes.
I may be all
Yeah,
way.
that's fine.
No,
No, I think you're right.
I
It's-
agree.
yeah.
I think that's a good idea.
Yeah.
It is a
That's
good
fine.
idea.
There's a lot of what I read from, I think Max of it from 14, 15,
Yeah.
the ones you gave us. Some of them were subjective, and it was interesting, I thought what the chief had up on the board today, I mean, she's already
She's gone
worked
through
on
it,
her goals
yes.
and objectives. And it looks like a lot of that can be with symmetry to her team,
Yes.
all the way down. And that was, I thought, very impressive. So I think
Yes.
it would behoove us to sit down and talk with the chief about this first,
Right.
and see what she would like to do.
Okay.
Suggestions, yeah?
Yeah, I agree with you. It is an impressive list of goals that you have. I don't have any problem of re-examining how we evaluate the chief of police. I make 2 points. One is that the charter requires us to evaluate the chief of police at least annually, not just annually. And in the past, this police commission has absolutely refused to do anything that was less than a year apart, or at least in my experience with the last chief.
Interesting.
There's really nothing wrong with these criteria. They're fine. In my view, the problem was that the police commission absolutely refused to examine the problems that were going on in the police department and chose to rely upon the word of Chief Kealoha as to how things were going in the police department. I think that was a fatal error, and I think we should be examining ourselves more than a list of criteria as to how we are going to proceed in the future and how we are going to make sure that we don't make that mistake again.
Yeah, and that's one of the reasons why I think that, as I said, in terms of what you wanted to let us know what was going on at the regular meeting, is take us along with your
Yeah.
trip, your journey there. And I
But-
think from that, we can answer the question or the
But I
question
think in
that
all fairness,
Commissioner
excuse
Sheehan-
me, I have to say, it's not fair. Mr. Takeda is not here to defend himself. I don't feel that that's what happened, that we refused to do anything. There were circumstances now over the last 4 or 5 years that I see that could have been improved, but I mean, I believe it'll be run differently now and perhaps better. And I'm thrilled that our new chief is as accommodating as she is and as brilliant as she is, but I don't think we sat here. Were you here for 4 years? I was, and I fought with everybody here. So, but I agree with Commissioner Sheehan that we can make use of the outlines that we have used, and yes, more questions can be asked and more answers from our counsel. Okay.
Well,
So the question I guess we have is that how we're gonna go about doing it.
Well,
So,
it's a
I'm
question.
open for suggestions on that, whether a pig or something, just to get some interaction going before the end of the year.
it's really a paradigm question. It's really, I mean, respectfully, I don't think that it's our role to ask the chief to take us along for the ride. We're an independent body. We represent the citizens.
Yeah.
We should be.
Well, let me correct myself.
Okay.
I said that basically is what, with lack of better
Informative.
wording.
Sure.
What I wanted to say is that we need to know what she's doing.
Very good.
So we can evaluate, and that's what I'm saying. As she goes along, she has all those different goals she wants to do. We'd like to know what's going on with those goals. So we can do what we do, or what we need to do, to whether it's done or not done. And that's what I was talking about. I'm talking about, just as you go along, we need to know that. Not to go along as for the right as a thing. Go ahead.
Well, both Commissioner Gibson and I, we're from the other, not in public, segment from our business and environment. I read all the review for the last few years, etc. I think the most important thing for me as a new commissioner on this commission is to build trust
Absolutely.
with our chief and our police department. And the form, they're good, but also I think it may be useful, be very useful for the new chief to react to it, because she has a new vision, a mission, and priorities that take us into a direction that probably from a priority skills, leadership communication from that area it could be very different from the previous chief. So this is a new beginning, this is a new start. I think it will be really good for us to look at your new vision, mission, and from your perspective, in order for you and the police department to be successful, what are the changes that you would suggest? And we come back together again. If you like, you can appoint a task force. No, there are only a few of us, so we don't have a task force to work with the new chief. I'll be very happy to do that, or because we do a lot of organizational organizational development in our private
We'll give you-
enterprise.
Yeah.
I mean, I would volunteer our services and come back to the commission. I just got volunteered.
Sure.
Commissioner Chang, I'll give you a new word. It's called pig.
Cool pig?
Hey,
Yeah.
Protect-
Permitted
Oh,
interaction.
oh, that's
group.
a new thing too. Oh, make me a pig.
Yeah.
Oh, that's not, I agree with it.
Welcome to the world of the sunshine.
No, I just think this is such an
Yeah,
important new
it is.
beginning.
Yeah.
And from a performance discussion perspective, it's our job and it's ongoing feedback, and not from a judgmental point of view. We're here to judge anybody. So I think that collaboration and relationship from day one is really crucial. So I would second.
Yeah,
Commissioner
no.
Levinson.
And also,
Okay, well, so
And,
I guess,
I agree.
shall we just, since time is short, maybe a pig would work, would do.
Time may be short, but I don't understand why.
why is time short?
Well, I think everybody's
sure.
wanting to move to the
Yeah,
new
we will
beginning.
move.
The
We'll
new
move.
beginning.
Yeah.
Well, I think
Timeline.
if I'm hearing everybody correctly,
you're right.
what it sounds like the consensus is that we would like the chief and her deputies perhaps to examine the old
That's
competencies
it.
and come back and have conversation with us.
That's
about
it. Don't throw out the whole thing.
Yeah.
There's some good
Right.
stuff there.
Yeah.
Right.
Yes,
Yeah.
yes, just to react.
Next meeting,
It's
we'll
a-
talk.
Yeah, this is a good template.
Yes.
Yeah,
Really is.
exactly.
We can help medicine.
Okay,
So-
with that in mind,
Have Aaron set
since
up a
I
date.
think we're probably gonna have only one meeting in December,
Yeah.
time frame wise,
Why are we gonna have one meeting in December?
because I think a lot of, we're not gonna have quorum, I don't believe.
For which meeting?
The second meeting in December, the 20th.
20th.
Yeah. Yeah, I don't.
I'll be here.
Yeah.
Okay, you give the
Form of
80
one,
hours.
form of one.
You give the 80 hours.
Out of curiosity, who's not here on the 20th?
I'm not on this
Yeah.
land.
Yeah, I don't
President.
think Jen, yes.
Yeah.
Yeah. I know, I think you might be, you're gonna be short.
Do we have 4?
3, 4.
Jerry's
can be
unknown,
here.
I thought.
No, he doesn't know.
I'll be
it.
here.
Yeah, Jerry
That's
doesn't.
I'll be
One,
here.
two,
I'm not here.
3.
Yeah.
Oh, we
He's
got,
not here.
we do
I'm-
have
I'm
4.
not here.
Oh, you're not?
And I'm not
No.
here.
Then we don't.
All right.
Yeah.
then. All right.
Yeah.
Then we don't have.
Okay.
So, that brings up the the timeframe.
No, really, what is the rush? Like,
No, I'm just saying, I'm trying to do a timeframe here.
As to when
It
you
could
can
be
do
the
it.
beginning, the
January.
first one in
Gotta
January.
be in January.
January.
all right.
Be
Yeah.
very
Still
thoughtful
be here.
about January.
Okay, yeah. No, I'm just trying to set up a timeframe here
Sure.
on.
You got a meeting on the 7th,
January.
2 days in a row.
On the what?
We do?
No, just joking.
Jeez.
Third.
So, okay, so why don't we,
January will
have to be,
be the
2 weeks
why don't we
from now
have
to be
that
the next
discussion?
Third.
Okay, why don't we have that discussion, Chief, at our next meeting then?
Okay.
January 3rd.
No,
December
no,
sixth.
no,
December
December
sixth.
6th.
December 6th.
Yeah.
Oh, okay. All right,
On the
okay, I'll
agenda.
be here, I'll be here.
Okay.
Yeah, December 6th. So we'll have, can you get her all
Is
that
that enough
information?
time?
So-
Is that?
Yeah, we'll
Yeah.
do it, no problem.
Yeah, we have that discussion, but look it over and see what, yeah, based
she
on
has
what you
to.
have on your thing.
Sure.
It's too bad
Okay,
she has to
very
be-
good.
What's wrong if we?
All right,
do it for 14 months instead of 12?
We're down to
Now we're gonna-
unfinished business.
60 days we have to. Yeah.
Yeah, okay, we have unfinished
Okay.
business. We have proposed amendments to
Oh, yeah, good
Rule
one.
10 and 11.
Yeah. Want to do that one.
All right,
So-
maybe we can do that in 2 pieces.
All right, well,
Because as I understand it, there really isn't any controversy, or we are not of more than one mind regarding the proposed amendments to Rule 10.
Right.
The proposed amendments to Rule 10 simply bring the rule into harmony with the recent amendments to the city charter. And I think Corp Council is on record as being fine with what we're proposing. So why don't
Why don't you
I
propose
take
and
that
I
first
second?
and
Yeah.
move that Rule 10, as we are proposing to amend it, be put out for public comment pursuant to Chapter 91.
okay,
Second.
been made and second?
Second.
Okay, any discussion? Hearing none, all those in favor say aye.
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 Any opposition? All right, thank you. All right, next one, Commissioner Livingston?
Rule 11, Corp Council and I, who have been in conversation for the last several months quite intermittently, at the request of the chair, not having achieved a meeting of the minds regarding proposed amended Rule 11, I move that the commission place the commission's draft proposed amended Rule 11 out for public comment. I understand that Corp Council is present and would like to comment, and in particular with respect to language that it prefers. That's fine by me. I should also add that in the course of our last discussion, a representative of Corp Council and I agreed that it would be useful to undertake a global review of all of our administrative rules, some of which I think require some updating. There may be some rules that we don't have and need, but that we do all of this in a considered, systematic way. And I'm happy to be part of that collaborative process with Corp Council if that is the wish of the commission. And I'd welcome anyone else on the commission to participate if they're authorized to do it.
Okay, why don't we get through Rule 11 first on the discussion? So, Corp Counsel?
Thank you, Mr. Chair. Dwayne Penning, Deputy Corporation Counsel.
He's excited. Good afternoon, Chair. Donna Leon, Corporation Counsel, Vice Chair Thompson. Welcome Commissioners Gibson and Chang and Chief Ballard. I would like to give Deputy Coroner Dwayne Tang the opportunity to address the Commission on the proposed amendments to Rule 11-1E and 11-4E that we have sent to you under cover of a letter back on October 9, 2017. And for the edification of the new commissioners, I've asked Deputy Clerk Pang to summarize the rationale for the amendments that we are proposing, which are very different from the amendments that Commissioner Levinson has proposed to the Commission.
I just want to clarify one thing, is that we reviewed the proposed rules that were drafted and sent to our office back in October. I'm sorry. We sent it to us on June 30th, 2017, and we understand that another set of proposed rules drafted by Commissioner Levinson was also submitted to the Commission, amending those. And we did review those. But in the meantime, we sent a memo dated October 9th, 2017, with our comments and suggestions. And as Commissioner Levinson said, we did not have any problem with Rule 10, and we were going to move forward with Rule 10. We had a suggestion to amend Rule 11-1E, which would, and that one pertains to the officer's request for legal representation. And it amended the language from person scope of employment, which is in your current rule, to coincide with the language that is in rule in the statute, which is performance of an officer's duties. And currently, the rules don't have any guidelines or suggestions as to how to interpret that. And in the past, we used employment law. That's why person scope, and Commissioner Levinson argued that that might be too narrow. We don't necessarily agree with Commissioner Levinson, but we took another look at it. And we found a case that interpreted the term performance of employment. And that statutory term in the Supreme Court said that that's what they're going to use to interpret that term, performance of employees, performance of employees' duties. And so we amended the Rule 11E to put in those guidelines. And the reason that we suggest that you provide guidelines is, number one, to provide the officer notice as to when he or she will be in the performance of his or her duty. And to be consistent with future commissioners who may come on board and kind of look at the term performance of a police officer's duty and say, geez, what is that? And if you have it in your guidelines and you adopt it, then that's what everybody's going to go by.
Dwayne, excuse me, which decision are you relying on or referring to?
I think in our memo we referenced
What?
That's the Intermediate Court of Appeals.
I'm sorry, Intermediate Court of Appeals. And Commissioner Levinson pointed out that there is no Supreme Court case that interprets performance of duty or even performance of a police officer's duty. But we would recommend that you adopt those rules, and because you are the expert administrative agency, normally the courts will give deference to that, to the administrative agencies. And like I said, if it's your new rules,
So we would have to adopt it, though?
You would have to.
Because at this point, the Supreme Court doesn't have that.
well, they really haven't interpreted, as Commissioner Levinson has pointed out, that actual term.
Mhm.
And I think that was a difficulty. We used the term course and scope. We thought it was very close, and probably our position, it was the same thing. Commissioner Levinson disagreed with us, and so we took a look at it. And so we would suggest that we use the guidelines in the Intermediate Court of Appeals, and that's referenced in our memo. I think all of you have the memo. Okay. In Rule 11-1E. We had also made another suggestion. We would ask that you adopt a new rule, Rule 11-4E. And this arose with the controversy of whether your hearings would be open to the public or closed to the public. And there were a number of arguments, a number of discussions, and in reality, in historical fact, I don't think anybody's asked that the hearings be open until, I guess, a few months ago. So we came up with a suggestion, and we're providing it to you, that the hearings be open to the public unless a police officer can show, let's get the language for you. The commissioner must give proper notice to the public, and they find that there is a strong countervailing reason to close the public hearing. And in making that decision, you can consider the officer's wishes, and whether he will argue constitutional rights, whether you believe or there's an argument that his keeping the hearing open would interfere with his or her criminal investigation or prosecution, or whether there's a specific statute that requires it to be closed. So, again, putting that in your rule will give notice to all police officers that when you come to the police commission, the hearings will be open to the public unless specific findings. I understand that Commissioner Levinson has suggested a different standard, and he had cited the Oahu publication case. And the language is almost similar, but the Oahu publication case, we felt it was very clear it was a guideline for criminal cases. And since this is not a criminal case, we felt the standard that was developed in a civil matter should warrant closing the case. And there are other reasons. Criminal cases, the courts are very wary of protecting a criminal defendant's constitutional rights. And most of the time, in fact all the time, the criminal defendant has an attorney representing him or her. But when the police officers come before you for legal counsel, they may or may not have legal counsel. It'd be advisable to have, but they in the past, I think historically, some officers have come before you without, and so that's why we were quite afraid of using the criminal case standard. We made a couple other suggestions. One would clarify your Rule 11, which would just state that an appeal, the officer is denied legal counsel by the commission would have 30 days to appeal to the circuit court. I mean, that's in the statute, but we just thought it might be more clear for the police officers. And again, we're on this notice thing, giving the police officers notice. We understand that Commissioner Levinson had cited a few cases in his proposals, and we would caution against citing cases for your standards, because it assumes everybody's aware of exactly what the case stands for. And as lawyers, we know that cases always can be interpreted differently by other attorneys. So if you put the standards in plain language as opposed to referencing a case, I think it would be clearer for the commissioners and police officers. And of course, cases can always be overturned, amended, and which may not come to our attention or the commission's attention immediately. So that's why we would suggest that the case law not be party rules. But if you like the cases, take the language from the cases and put it into your rules. I think that's all I have right now. If there's any questions.
Any questions for the co-counsel?
Yeah, I have
So-
a couple of questions.
Well, before we do that, so what your suggestion is 11(1)E is on page 2, that language, and a separate one, 11(4)E on page 3?
Yes, I think it's highlighted in our memo.
These
Yeah,
pages
that's-
aren't numbered.
Regrettably, our draft rule does not have pagination, but if you were to manually put pagination.
Yeah, I noticed that, yeah, there's no,
11(1)E
yeah,
is-
it's mentioned yellow, but there's no yellow marks there, yeah.
It's
But it
gray.
is page 2, if I'm correct?
Page 2 contains
And-
11(1)E.
Yeah.
And page, excuse me, page
3.
5
Oh,
contains 11-4E.
oh, I'm
Is the
sorry.
start of 11.
I only got, I'm looking at your memo of October 9th.
Yes.
Yeah, it has only 2 pages.
No, it has.
So the memo of October
Oh, this one?
9th is at page 2.
Oh, okay, yeah, yeah.
Right, is 11(1)E,
No,
and
that's-
at page
that's-
3 is
yes.
11-4.
Oh, okay, got it, thank you. Okay, sorry, Commissioner Freehan, go ahead.
Yeah, so my concern is with your suggestions for Rule 11-4E, where you're talking about closing the contested case hearings to the public. I'm afraid, I disagree with your analysis. I think that you're mixing up, you're mashing together two different concepts. Correct me if let me walk you through how I see it, and then you tell me where I'm wrong if you think so. The police officer has a right to an open hearing, a public hearing, okay? That's by virtue of the due process clause, right? Okay. Completely independent from that, completely distinct from that. The public and the media has a right to an open hearing, an open contested case hearing, correct? Okay, so,
Actually, I beg to differ.
okay.
So we have read quite a few cases on that particular point, and it really depends on the type of hearing that you have and the subject matter of the hearing. Dwayne's read the cases, I've had several deputies read the cases, I've read the cases. You really have to parse it into what type of case it is, civil versus criminal, and then the type of matter about which a party has requested open or close. And it really requires that type of parsing. Here, where you have an administrative hearing, which is what this is not a civil lawsuit, it's not a criminal lawsuit, you have even fewer cases on point. And what the courts have looked at also are whether traditionally the hearing has been open or closed. For this commission, and I can anticipate Commissioner Levinson's response, but traditionally, in this particular venue, for this particular issue, traditionally, the hearings have been closed at the request of the officer. And it's for exactly the reason that you just stated, Commissioner Levinson, and that is they were, the right to the openness of that hearing has been in favor of the officer. And if the officer desires for it to be closed, the request is made and the hearing has been closed. And many, many times it's been closed. With regard to the public's right to an open versus closed, again, case-by-case basis, and the courts look at the type of hearing, traditionally what has happened, and the interest to be served.
Okay, so let's look at that second issue, because I don't have any disagreement with the due process analysis, okay? But the second half, the public's right to know what's going on, the public's right to attend a hearing. So the parsing, as you put it, it should be done is a policy matter. It's based upon whether we think the public should be able to watch, whether we think this is a good thing for as a policy matter. Is that accurate?
Well, and the policies that.
No, I just asked you if I got that right. Did I get that right?
I think that is correct.
It's a policy
but
matter.
Based on legal precedent established by the courts, considering all the different.
Okay, so the
factors
policies
that
so the policy here is, that we're looking at in terms of the public's right to know, is whether we as an administrative body are going to spend taxpayer dollars. Is that right? That's what we're doing here, right?
And whether the officer under 52, HRS
No, that's the due
52D8
yes.
Well, I'm sorry.
Go ahead, please. Finish your, I could, well, please.
Thank you. It's not only about the expenditure of taxpayers' dollars. It's also, the question is, under 52D, 8 and 9, the officer is entitled to legal representation provided by the city in this particular case. And when we look at the whole ball of wax, there are personnel issues involved. The case law indicates that under 52D, 8 and 9, there's a property interest that a police officer has in being provided legal representation by the city. And that's why before you take away that property interest, potential property interest, you have to have a hearing. And before you close the hearing, there has to be an opportunity, and this is under case law for all the different types of cases, there has to be just the opportunity for the public to be heard about whether that case should be opened or closed. It's not that the public, which includes the media, has a right to an open hearing. They have the right to be heard as to whether the hearing should be open or closed, but they do not have, the public does not have the right to an open hearing. That's number one. Number two is, in this particular case, the request that's being made is for legal representation. And typically, even going out to find counsel to represent you, whether it be in a civil case or a criminal case, that's covered by attorney-client privilege. That should be treated confidentially. And that's why balancing the interests, balancing all the cases that we've read, we've basically turned it around and said it should be open unless there is a strong countervailing reason for it to be closed. The strong countervailing reason could be presented by SHOPO, which oftentimes represents the officer who's requesting legal representation. It could be closed on the basis that it would be against the officer's interest. It could be closed because they are trying to find legal counsel, which is a fundamental right to justice and being able to assert your case in a civil or criminal trial. And also, as Dwayne pointed out, sometimes the officers do not appear with counsel for whatever reason. And the statements by the officer may prejudice the defense of the criminal or civil case. So there are a lot of reasons why the commission may determine, after an opportunity for hearing, to close the hearing. And I've heard Commissioner Levinson say that his opinion that the decision by the commission should be made solely on the complaint, allegations in the complaint, and I really beg to differ with that, because I think before you take away a property interest of an individual, you should give that individual a right to be heard. But sometimes it needs to be in a closed session, thus the strong countervailing reason, and if you find it, you should close the session so that the officer can ask you for legal representation, and the officer's testimony can be held in confidence. There's also personnel reason for that. And lots of times when, this type of a right is oftentimes treated as a personnel right, which is a confidential matter and under employment law. And again, for all of those reasons, looking at all of those different areas of law, and not just this particular issue at hand, we felt that the proposed draft rule for 11-4E is the way to go, and that's our recommendation.
If I could
Go ahead.
Yeah, go ahead, Commissioner Levinson.
In a an email addressed to me dated September 22, 2017. Corp Counsel Leon set out
Excuse me.
her reasons.
Was that email addressed to the commissioner?
No, it was addressed to me,
And
wasn't
that's-
designated as confidential. I don't regard it as confidential. The Corp Counsel asserts 3 arguments supporting its language for the openness provision of Rule 11, and in particular, Corp Counsel's version of it. First, she wrote that it was intended to cover Fifth Amendment process in closed session. The second reason, well, with respect to that, the testimony, if presented at a hearing open to the public, may impair criminal investigations or prosecutions. Corp Counsel sought that language because it was intended to cover the Garrity rights situation, and I'll talk about Garrity rights in a moment. And then the third language, whether there is a specific statute or rule that mandates confidentiality, the observation was that's not an issue, it kind of speaks for itself, and obviously, if there is a specific statute or rule that mandates confidentiality, then it's confidential. I think that goes without saying. Officers are entitled to legal representation at city and county expense, either in a civil proceeding, civil lawsuit, or a criminal prosecution, if they are being sued for acts done in the performance of duty as a police officer. If they are being sued for acts done in the performance of a police officer, performance of duty as a police officer. What the officer is being sued for is what is alleged in the charging instrument. In a civil action, the complaint.
Right.
In a criminal action, the indictment or the criminal complaint or information. So it's the allegations of that charging instrument which determine whether the officer is being sued for acts done in the performance of duty as a police officer. The police officer ought to have no interest whatsoever in presenting testimony further to what he is being sued for. What he's being sued for speaks for itself. It's in the complaint. It's unambiguous. It says what it says. So any concern that the officer might be forced to incriminate himself in giving testimony to this commission in order to persuade us to give him legal representation is a misplaced worry. The officer shouldn't be testifying at all. The Garrity case is completely off point. In
Garrity has to do with an officer being forced to testify
Yeah,
in an employment position.
in Garrity, police officers in New Jersey
Right.
were required to give testimony that could be self-incriminating, I believe, to the police commission,
To,
a police commission.
like internal affairs kind of thing.
In an internal affairs kind of context. And one of the conditions placed on all of that was that if the police officers refused to testify, they would be fired. So they were required to incriminate themselves if there was something incriminating that they would have to say. That simply doesn't translate to this situation.
And just to be clear,
The request for legal, I mean, we're not talking about a condition of the police officer's employment, and the police officer is not under threat of termination for saying anything in the proceeding. And the police officer not to be testifying at all in any event. So the Garrity case is simply misplaced. And it's with respect to those two matters that the Corp Counsel's suggested language differs from my suggested language. My suggested language comes from a 2014 Hawaii Supreme Court decision. Yes, it involved a criminal case. It had to do with the access of the press to a phase of a criminal proceeding, but our Supreme Court had already held over a decade earlier that administrative contested case hearings are open to the public in the Freitas case. And so in the Oahu Publications case, the court set out a test regarding when an overriding interest of a defendant outweighs the right of the public, including the press, to be present at the proceeding. And so I incorporated the language of the Hawaii Supreme Court in that connection. With respect to the first section, having to do with elaborating or creating a formulaic test for when an act is done in performance of duty as a police officer, I have a serious concern. And my serious concern arises out of the defective rule that we have been required to operate under that was promulgated in 2004, I believe drafted by Corp Counsel, and injected into the question whether an act was done in the performance of duty as a police officer, the construct of course and scope of employment. That construct, Corp Counsel imported from a Hawaii Supreme Court decision called Henderson. Henderson had nothing to do with administrative law, it had nothing to do with contested case hearings, and it had nothing to do with government. And in fact, it had nothing whatsoever to do with a person's right to legal representation. What it had to do with was whether the Henderson Trucking or Painting Company or whatever it was vicariously liable for the negligent conduct of its truck driver when its truck driver ran somebody over. And so what the Hawaii Supreme Court did was to look to the restatement of agency law to determine the circumstances under which an employer is vicariously liable for the negligent conduct of its employee. And the Hawaii Supreme Court simply accepted, quite reasonably, holus bolus, the language of the restatement of agency with respect to when an act is engaged within the scope of employment. course and scope of employment as a general matter computes in the context of workers' compensation. A person is entitled to workers' compensation if the injury or accident arose out of and in the course of employment, or put differently, occurred within the course and scope of employment. And Corp Counsel then imported course and scope of employment analysis into performance of performance of duty as a police officer rule, didn't reveal the source of that importation, secretly fed us memoranda during contested case hearings expounding on Henderson analysis when the requesting police officer had no knowledge of that secret advice that we were getting from Corp Counsel. And for years, the commission, lacking attorneys on the commission or attorneys who were paying attention, simply accepted that construct. It's precisely because the importation of an extraneous formula that computes in another context can wreak havoc on the proper functioning of a rule that I'm concerned about importing any formula from another context into our rule regarding whether a police officer who requests it is entitled to legal representation for alleged acts done in the performance of duty as a police officer. As I mentioned, I am happy and even eager to get together with Corp Counsel over the course of the next year and take a look at all of our administrative rules, again, including Rule 11, and maybe we can recommend some further changes to Rule 11 then. I rather suspect we'll have a number of suggestions to make when we're done with our work, because there are rules that require tinkering as we speak, and there are rules that there are subjects that ought to be covered by rule where we have no rule at all. And so you'll be hearing from us again. But I think as of now, Rule 11, as we have proposed it, does the job with the understanding that an officer sued for acts done in the performance of duty means that the operative acts are the ones that are alleged in the complaint, and having now almost a year's worth of experience evaluating requests for legal representation under Rule 11, I don't think there's any particular difficulty in, I think it becomes very clear which alleged acts are alleged to have been done in the performance of duty as a police officer, and which alleged acts are acts that don't apply to police work at all, but other things. And so we're fully capable of passing on these requests without the importation of a formula from another context.
Okay, I'll give you a couple of minutes to rebut on that.
Thank you, Chair. I intend to be very brief.
Yeah.
So as Commissioner Levinson indicated, the previous rule was adopted in 2004. If you look at our letter, the Hua case that we cited and based upon which we faced the suggested guidelines for determining the performance of duty is a 2006 case. You know, and all that we're trying to do is to make it better, make the rule better. And that's what our proposed language seeks to do. I would say that under 11E, -1E, all we're trying to do is to provide the commission with guidelines with which to decide whether the officer was performing his duty or her duty in the context of, within the parameters of 52D8 and 9. I would say that even in his statement, Commissioner Levinson is providing you with guidelines that are not even in his proposed rules. And that is, number one, he says, look at the complaint only. That's not in the rule. That's a guideline. And number two, he says, it's going to become clear what does and does not apply to police work at all. That's a guideline. And that type of language is not found in any case law that we looked at. Rather, Hua was a case for a different administrative agency, the Employers Retirement System, but it used the same language, it interpreted the same language, performance of duty. The language we have on page 2 of our memo summarizes what we gleaned from the Hua case and applied it to your rules. So I would submit that even Commissioner Levinson, in arguing for not putting any guidelines in there, but using just express language of 52D8 and 9, is contradicting himself because he is applying guidelines that work for him. So we would recommend again our language for 11-1E. For 11-1-4E, the reason that we are saying that you have to give the officer a chance to say something about open and close, again, it's because it's a personnel matter, and before you take a property interest away from anyone, you have to give that person an opportunity to be heard. To just simply, I'm sorry, I'm back on -1. To just simply say it's on the complaint only, and you don't get a chance to talk, we feel violates personnel employment law. And I will tell you that I'm relative newbie back to court. The deputies know a lot. I acknowledge my email to Commissioner Levinson, says whatever it says, but even between September 22nd and October 9th, we became even more educated, and the rules that we're proposing, while I came to the conclusion that I didn't think guarantee rights applied either, we came to the conclusion on our October 9th memo that this is the right thing to do, and the best on all the case law that we had interpreted in all the various areas of law, and we would ask that we would recommend to the commission that it adopt our form of rules.
Just
Yeah.
in brief.
Can you take a break?
Hold up. Brief rebuttal on.
Just brief response. With respect, I don't believe I'm suggesting any guidelines at all. Just by way of illustration, say a police officer requested legal representation with respect to a criminal case which charged him with abuse of family or household member. And the charging instrument alleged that on such and such a night, he beat his wife up at home at 2:30 in the morning. Is there any question as to whether that is an alleged act done in the performance of duty as a police officer? I don't think so.
Okay. Real briefly, Commissioner Flores would like to take a short break.
Sure, I can.
Go ahead. Do you
I
want
can-
to
all right,
say
so
something, Commissioner?
So this is what I'm hearing with regard to you're wanting to give the police officers the right to exclude the public and the media. I think what you're not hearing is that the statute says if a police officer is, as Commissioner Levinson just pointed out, is sued for acts done in the performance of his duty. Now, maybe those acts didn't happen. Maybe the complaint is totally false. Maybe the complaint is totally wrong. But if the piece of paper, if the charging document says you did these acts, you did these things, there's no need for the officer to come in and say, but what I'm thinking, this is I think the intellectual difference. You're thinking, we have to get to the bottom of this. Did he do these things? Did he do them in the performance of his duty? Is this what he should, was he ordered to do this? I think what Commissioner Levinson is pointing out is, if the paper says it, the officer gets it. And there's actually no need for the officer to come and to testify or to say anything. It's like a DEC action, a declaration action in insurance law.
Commissioner she can,
Yeah.
respectfully. I have thought about that.
Okay.
And basically what you're doing is you are giving to plaintiff's counsel the power to decide whether to provide legal representation to a police officer. Because I have seen it recently, and I know exactly what they are doing. And all they have to do is to say that this officer was acting, was acting in
I
their
wish
official
I could come
capacity
back.
as a police officer. Why
No,
go
no, no,
any
no.
farther? No, I'm telling you, I have seen that in the complaints, and I know exactly that's what they're doing. So if you just look at the face, and there's an allegation that they are acting in their official capacity as, well, in the performance of their duty as a police officer, right? That's all they have to do is listen to this discussion. Then
Then-
based on that position, you will 100%
Okay.
be having the city defend these officers. And I'm sorry, the example he gave was very far right, right? I mean,
Sure.
rape is the absolute worst. But there are times when an officer may allegedly be doing something that is in what they're supposed to do, you know, like making an arrest, and then all of a sudden it goes from making an arrest to bam, 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 and the person's dead. Now, tell me, is that in the performance of the duty?
Of course, if he's making an arrest, yes, of course it is.
So therefore, that person, that officer, has manually beaten a person to death.
Yes.
That's in the,
The
Yes,
statute-
absolutely.
the-
That's
the-
it.
The statute.
If it's in the performance of his duty, he can do his duty poorly, wrongly,
The statute on
illegally.
its face.
Excuse me, we have discussion on this, on my right-hand side here. So you're done, so you have a comment? After that, I'm going to call a short recess, and we'll come back and call for the vote.
Yeah, so I hear you on your concern, and I actually had that same concern, that an attorney, in the manner in which he or she chose to draft an indictment or a criminal complaint, would control whether a police officer would receive legal counsel under the statute. I thought of that as well. And so, don't you think, however, that this commission would have to look for facts that are alleged in the charging document, and not just conclusions such as the one you gave, you know? So, for example, if there was an indictment saying this officer was home, it was the middle of the night, he beat his wife, they're intimate partners, he's guilty of abuse of family and household member. Oh, and it was done in the course and scope of his employment. Don't you think that this commission would have to examine the factual allegations as opposed to broad conclusory statements?
Okay, one more answer, and then we'll call, I'm going to call for the vote. I think we've had enough discussion on the issue. You going to answer that question?
no, I think I've made my points.
Okay.
Thank you.
All right.
Then I want to make 2 points.
Brief, I give you
Very
2 minutes.
brief.
Very brief. Make it brief.
One is the allegation in a complaint, a charging instrument, that all of the acts of the defendant were performed in his official capacity as a police officer is not a factual allegation.
Correct.
It's a legal assertion. And we do not have to accept, for purposes of the request for legal representation, legal assertions as true, only factual allegations, for purposes of the right to representation. The second thing is that on its face, the statute which entitles a lawyer, a police officer to legal representation when sued for acts done in the performance of duty as a police officer, presuppose the possibility that the officer's conduct is unlawful. The fact that it may be unlawful is irrelevant
Right.
to whether it was performed it was done in the performance of duty as a police officer, and that's why beating the tar out of a suspect after he's been arrested, the officer being authorized by law to make arrests, is charging and is being sued for an act done in the performance of duty as a police officer, even though the conduct is unlawful.
Okay.
I can understand that.
going to end discussion at this point, and we'll call for Commissioner Levinson, I believe you made the motion
Yes.
to accept.
Have we already dealt with Rule 10?
Yeah.
Yes,
yeah.
Tim's done
Yeah.
already, Tim's done already.
Yeah.
Yeah, we
Accept
have.
your version.
The motion is to put the commission's version, which is my version, of proposed amended Rule 11 out for
Okay,
public comment.
and you seconded?
Second.
All right, motion be second. Discussion. Any discussion? Yeah, I'm going to say something. I was hoping that this whole process, when I asked Commissioner Levinson to work with Corp Counsel, that would come to some agreement, the meeting of the minds. And apparently it has not. And I'm going to be consistent with what I've been saying all along, that I've mentioned that Corp Counsel is our lawyers. We are the client. Yes, I agree with Commissioner Levinson. And however, being a lay person, and because there's no agreement here, I'm going to stick with Corp Counsel on my vote. So any other discussion on that? Comments?
Chair, I get that this is a confusing area. And I get that it's confusing for it's confusing for people who studied it. It's confusing for lawyers. Simply because we've done something I propose incorrectly in the past is not a reason for continuing to make the same mistake. The statute is super clear. If you're sued or charged for acts that are done in the performance of your duty, you get a free lawyer. That's all. That's what it says, and that's what Commissioner Levinson is proposing that we put into our rules. An officer can do his or her duty badly, illegally, wrongly, and he or she still gets a free lawyer. And that's kind of a red herring. So I would urge you to reconsider, because I think that the rule is in its current state, and the current standards that are given to us time and time again by Corp Counsel are wrong, they're illegal, and I think we're under a duty to correct it.
My feeling is, okay, I mean, that's two different opinions. Can we get a second opinion?
That is the
A
second.
third?
That's the third opinion.
I mean, two disagreement, get a second opinion. I mean, get someone else to tell us it's right or it's wrong.
Oh.
Because
I think that's when you have two lawyers, that's for the courts to decide.
that's why I was saying, got someone to.
I think we would be
So why don't
covered.
you get a mediator, come in, arbitrator to come in to.
No, we need to proceed on.
Okay,
We need
so
to
just
call
vote.
for the
Okay.
vote.
Just vote.
All right, no other comments, questions? Okay, call for the vote. All those in favor of Commissioner Levinson's proposal, say aye. Raise your hand.
How many saying aye?
Okay.
Well, it's four, they got it
Yeah.
already, then, huh?
All those opposed? All right,
Thank you, Commissioner Levinson.
all right, very good. So that's passed.
like to
Now,
say-
real
Okay.
quick, so does that, so
We'll make the
just for the
changes.
clarification, it's this one, Commissioner Levinson?
Yeah.
That's this one?
Yes.
Yeah, okay. All right, thank you very much. We'll take a short break. I think Commissioner Levinson and I need to go use the
How do I say, okay, I love you, but I'm going?
No,
I really,
wait.
oh, okay, wait, I can't go yet. I start my real job at 5 o'clock. What, how can you keep me here? And there's no compensation here.
All right, we're back into regular session.
Yeah.
Next one is Mr. Lawrence. I think you're up.
Good afternoon, Commissioners. We just wanted to discuss the status of the contested case hearings because we've been instructed to defer them until we
Yeah.
resolve.
Only one, though.
No, we deferred two.
Oh.
And there's another one in the hopper, and then the Chief Kealoha one as well. Now that we understand that there's an agreement and we can put out public notice for a hearing, the way the timing works, I already had the notice drafted that the hearing would be on December 20th, and that way we could have something ready to implement for January, so we could start listening to these officers, listening to their hearings.
Okay, the 20th, but the
It's
20th,
off.
we're
Well-
gonna be missing, but this is just, who's gonna be conducting the public hearing
It's just, we would just have it here at the meeting.
on the 20th? But,
Well, we can't now because there's no quorum.
December 20th.
okay,
Right.
This one,
Um,
December 20th.
So it'd be January 3rd would be the public hearing, then the mayor needs to sign off if the commission adopts the proposed rules, and
Right.
then file it with the clerk, and then there's a 10-day waiting period. So the officers would not have the opportunity to be heard until probably the 17th of
That's his
January.
okay.
You heard that?
Are we gonna have a meeting on the 3rd?
Yeah, I believe so. I think.
You guys
I'm
going,
sorry.
who cares?
The
We
third-
have a meeting on
January.
Yes.
January 3rd. Yeah.
All right, so far, I think we should have a quorum for
We'll
the
have
3rd.
quorum, right?
Yeah.
Okay.
So the 3rd would be the hearing for
Public
the
hearing.
rules?
Public hearing.
Okay,
17.
Okay, so I'm going to schedule as many of these hearings as can on the 17th, because
Okay.
the attorney for Naki Amoso is very concerned, and he wanted
Okay.
to be heard today, but I told him that it's not
okay.
possible.
So 17th is when we're gonna do the contested case hearing? Okay,
Correct. If-
that's the schedule?
Yes.
Okay, all right. Any comments real quick? No? Okay, thank you. You have your executive officer's
Yep.
report?
Good afternoon again. As of November 15, 2017, 70 complaints registered compared to 76 last year, and we have 7 pending. And today, we're distributing to you 3 new complaints and 3 complaints for PSR.
Okay. Any questions? Okay, hearing none. Commissioner Sheehan, you're up.
Is Corp Counsel, oh, you're staying for this executive?
She's
Okay.
gone.
Yeah, for the executive.
Okay, so the following agenda items will be reviewed in executive session pursuant to HRS 92.5A subsections 2, 4, 5, 6, and 8 to consider the hire, evaluation, dismissal, or discipline of an officer or employee, or of charges brought against the officer or employee, where consideration of matters affecting privacy will be involved, to consult with its attorneys on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities, to investigate proceedings regarding criminal misconduct, to consider sensitive matters related to public safety or security, to deliberate or make a decision upon a matter that requires the consideration of information that must be kept confidential pursuant to state or federal law or court order. So moved.
Second.
Been moved and second, discussion. Hearing none, all those in favor, say aye.
Aye.
Okay, we're now in executive session.